is just fantastic.
Hello everyone, welcome back to another video. I have been sent via email by a very lovely individual. I think it was you, Madcatster, but the name was not the same, so I don't know if it was you for certain. If it was, please let me know in the comments. I'm going to link Madcatster's channel anyway. A PDF file. Now this PDF is a legal document, a plaintiff's second amended complaint. It has a fair amount of redaction to it. The plaintiff is Iilluminaughtii. The defendants are listed as former employees of Pyramid Entertainment. Pyramid is a company that is owned entirely by Blair, aka Iilluminaughtii. From a legal stance, Blair's not doing so well. She really isn't, but she is persisting, and I have to admit I'm somewhat impressed. I'm somewhat impressed that she is still bothering with this charade, this facade, knowing that she is not doing so well on it. If you don't know who Iilluminaughtii is, I'm going to link a video I have done on her in the comments down below. It'll be a complete compilation of other videos I have done, so it's just easier to digest one big video. I highly recommend you watch it for context. The channel of Iilluminaughtii is continuing to nosedive. It is continuing to nosedive from a channel that at its peak would average hundreds of thousands of views a day, all the way down to about, well, 11 days ago, 12,000 views. She dabbles within politics, she dabbles within anti-MLM content, other social commentary as well, and it can be argued there is a sprinkle of philosophy. It is safe to say though the channel of Iilluminaughtii is kinda dead, and I think Blair knows this, hence the rather feeble attempts at continuing to try to destroy those detractors. She has not been the most active on any other platform, she really isn't. This could be because she is doing the legal process and believes that by doing so she will monetarily benefit. The problem here is for her, as covered by Madcatster on a semi-regular basis with legal updates, she's not winning. Something which many of us had speculated would be the case because we couldn't imagine or envision a reality where she would come out on top or be able to rebuild because of it. At best, she would get some compensation, and she's not getting any of that right now. What I thought we'd do, as it's an 18-page document, is go through what isn't redacted. Now I've noticed some parts have been highlighted, which is very generous of the individual who sent this to me. I think it's Madcatster. We'll go with and start with factual allegations. The defendants are former employees of Pyramid Entertainment, wholly owned by Blair. Pyramid created and managed the Sad Milk YouTube channel, which posted humorous videos responding to funny internet memes. Blair also maintained her own YouTube channel, Iilluminaughtii, a moniker by which defendants would refer to her in public statements identified later in this second amended complaint. One of the defendants signed a confidentiality agreement in 2021, which all employees are required to sign as a condition of employment. One of the defendants is Wonderstruck Guy. Oh, that name rings a bell. Ooh. They also, Wonderstruck that is, operate a public Twitter or X account, alternatively rendered as Hi, I'm Wonder. Wonderstruck have been very vocal in their criticisms of Blair, and this NDA argument is going nowhere it seems. Defendant signed a confidentiality agreement on the 4th of October 2021. This individual is Oz Media. Felix the Kit Kat is another who'd signed a confidentiality agreement in May 2021. Collectively redacted to be referred to herein as the agreements. Interesting. Additionally, defendant entered into an NDA agreement on June 2022. All the defendants' confidentiality agreements contain language pertaining to the employee's understanding that by entering into this agreement they are obligated to, and the plaintiff's goal is to protect its confidential proprietary information and ensure that all employees agree to maintain the confidentiality of Pyramid Entertainment information. Defendant blank, I wonder who this one is, and Blair began a romantic relationship in or around May of 2020 and began living together in the defendant's house in or around January of 2021. This defendant, in September of 2021, was hired to act as a project manager for Pyramid. In December 2021, Blair ended the relationship and moved out of his home and purchased her own home. In or around August of 2022, Blair decided to sell this home and commission a new build home, back when she was flush with coin. As defendant and Blair were still good friends at this time, they decided that she could reside at or with this defendant while the new home was being constructed. During this time, Blair had just undergone surgery and was taking painkillers. Her memory was limited during this period. Because blank believed she, so Blair, and Mr. I wonder who, to be on good terms, he cared for her for a limited time to help her recover from surgery. I like these documents. They provide fantastic insight into the context of one's interpretation. I'm quite intrigued by Blair's inability to remember things because of the painkiller intensity, and yet still these complaints are brought forward as if there's enough fact to go on. Because surely if she was compromised, actually she wouldn't have as much of a memory on things. Unless this is done to defend herself. How can she remember anything when she was under the influence, right? But then to reverse and throw it at somebody else when you yourself can't remember enough of it in the first place, or selectively can remember enough of it, seems a bit peculiar. During this time, the defendant told Blair that he had taken a forbearance on his home loan, and that if she did not provide him with 6 months of mortgage payments, she was going to be evicted from the house because the bank was going to foreclose on his home. Blair does not remember this episode, but her sister and friend were present who do. They stymied the defendant's efforts to coerce Blair at this time, implying a form of extortion. After Blair had stopped taking these painkillers and regained her ability to retain memories, the defendant stated she had promised to provide this money, and feeling obligated based upon the fact that she had no recollection of the promise, did so. During this period, the defendant stopped caring for Blair, and she was almost hospitalized because of this lack of care, which was previously administered. Around the end of August 2022, Blair confronted the defendant, who eventually agreed to a payment plan to repay the mortgage payments he had wrongfully coerced from her over a period of approximately 2 years. However, the defendant later altered the payment term to 10 years, or repayment term to 10 years. This payment plan was memorialized and executed by defendant and Blair. Over the Christmas and New Year's holidays, Blair began seeing a new person romantically. How exciting. By early January 2023, Blair had moved out of the defendant's home because she felt uncomfortable around him. She lived in a rented home while she awaited the January 15th, 2023 close date on a new home, and her belongings were still in defendant's home in a room entirely set aside for storing her belongings. Without her permission, during the interim period, it is alleged that her computer was accessed and personal messages read. In doing so, he learned that Blair was romantically involved with someone else. She didn't think to tell him? I mean, it's not really his business, but you'd think living together you might mention it. On January the 4th, 2023, the defendant contacted Blair's employee and told this person that Blair had cheated on him despite the defendant and Blair's romantic relationship ending in November of 2021. After Blair was informed of this, Blair confronted the defendant, who admitted he had impermissibly accessed her computer. On the 6th of January 2023, the defendant reached out to another defendant via text and stated that Blair played him in reference to Blair cheating on him, despite that their relationship had ended over a year prior. Blair was only aware of the messages because both defendants had published them in a video created to badmouth Blair. Starting to feel more schoolyard now, isn't it, everyone? I love it. Blair is under the information and belief that it was around this time that all defendants began plotting to effectively ruin her business, reputation, and life, something which has later been proven to be not true, and she destroyed it herself. The straw that broke the camel's back was less them, it was more her going after Legal Eagle. It then shone a massive light on her because of how stupid she looked. Around the same time, Blair received a text message from another defendant to update her resume because Blair's company would not be around much longer. Dun dun dun. In or around the latter part of April 2023, defendant published a series of Twitter posts naming Blair as the aggressor and falsely claiming that she has a habit of starting fights. These include confidential information. Now we know who this is because they include a link to a tweet from Oz Media. It should be noted, I mentioned Legal Eagle there. She tried to start a fight with Legal Eagle over an editing style, which he had been doing years prior to her. She claimed it was her unique quirk. Well, I guess in this instance then, when it comes to lazy cropping and avatar still images used in 2024, do I get to claim that as mine now? There aren't many of us skeptic clones left anyway. Can I do that? Maybe I should sue everyone else that tries, because that'll totally make me some money. After Oz Media published these inflammatory posts, Blair began receiving threats from third parties through Twitter, Discord, YouTube, Twitter, Instagram, and email. Blair made her first call to the police in this regard in or around April 23rd, 2023. After this incident, Oz Media contacted another former Pyramid employee and attempted to harass her into disclosing private information about Blair so that the defendant could exploit it publicly. Very inflammatory language, don't you think? Because people simply having a conversation can just be a conversation. right? To immediately assume the worst, presume the worst, or indicate the worst. Hardly a surprise, I guess, in this. It's very desperately written, don't you think? Everything is negative, everything is black-pilled, everything is nihilist. The world is against Blair, it is a conspiracy. Reality is, your shitty actions have brought you this low. One very important aspect that needs to be highlighted is that these green parts are, I believe, the amended parts. And in this, Blair is trying to defy the judge and portray herself as somebody that is not only a victim, but somebody who was coerced into a lot of rather shady dealings that may act as a mitigating factor in better helping her secure victory. We'll continue to prove this by going through more of this document. On July 25th, a defamatory video titled "The Fall of Blair, YouTube's Biggest Bully," my apologies, thou corrected, biggest bully, was posted about Iilluminaughtii. This video was published by Madison Harnish. In that video, the defendants speak publicly about their intent to publish another defamatory video about Blair and Pyramid with a timestamp included. On or about September 16th, 2023, the defendant released a video titled "Let's Talk an Update on Iilluminaughtii Drama." Wonder who that one was. In this video, he speaks about how he believes the video will be used in a courtroom and includes false allegations of embezzlement. Quote, "Which wouldn't be surprising considering Blair's alleged white-collar crimes I intend to expose with evidence within my video." Timestamp 454. The defendant clarified that the white-collar crime he was falsely accusing Blair of was embezzlement. Just for the sake of those who don't know who this was Oz. Prior to defendant moving to Colorado in or around May of 2021, Blair purchased a car that she allowed him to use as his own. The car, under the assumption that he would repay those funds, which Blair and the defendant agreed and understood to be a loan prior to her transferring the title to him. This has been a very contentious part for Blair. She claims much in the way of damage and destruction was done to the car along with payments not being made on time, and that the police had to be called. When the car was eventually seized, possessions belonging to this defendant were still in the car. Because they weren't in the same state, this got a bit muddy, murky, hassly, bothersome. Amended, after Blair left the state, the defendant texted her stating he wanted to, I believe, unalive. Fearing that he would follow through on this threat, Blair contacted the police department to perform a wellness check. After the wellness check, the defendant contacted Blair stating she should no longer contact him, and she has abided by this request since the date it was made. Yes, I misspoke, sorry about that. Approximately 1 month after the above occurred, defendant's father sent a demand letter seeking personal belongings from the vehicle. In or about August of 2021, Blair filmed the unpacking of the vehicle. The defendant can be seen and heard in this video. While unpacking the vehicle, Blair found documentation of the intent of this defendant to permanently relocate to Texas despite his assertions that he would be moving to Colorado and working with Blair and, well, Pyramid. From that time, the defendant was virtually silent until the defendant contacted someone and they discussed and created a plan to obtain revenge on plaintiffs. Okay, that's not highlighted, but there you go. In or around April of 2023, Mr. Blank created multiple Twitter threads with many unsubstantiated and false claims, including but not limited to that Blair unlawfully repossessed his rental car, Blair stole money from employees in the form of wage theft and more. Well, she has gone defensive on this part, the wage theft part, by stating that she doesn't take more than $600 because she was using the majority of the money made, well, when the channel was making money, paying her employees. Wage theft is a tricky area to navigate from what I've heard, because there's the idea and argument of what is dubbed modern slavery. How you regulate this as a business, I don't know, because I don't run a business. I'm just some dickhead with a microphone. I know my limitations, if that makes sense. But this, much like the car, which I do believe was there a play button in there? It took ages to get that play button back, a new one sent from Society Awards. These ones have been hotly contested, and if these are the amended parts, Blair is further trying to make herself look like she's not only coerced, manipulated, but like she's a living saint and didn't do nothing wrong. I can't believe I've had to say didn't do nothing again. I haven't said that in a while. It's a bit antiquated. We're going to skip down to the first claim of relief, brackets, breach of contract for all defendants. Blair and Pyramid hereby incorporate the previous paragraphs by reference as though each were fully set forth therein. Plaintiffs and defendants have entered into valid and binding contracts supported by adequate consideration, as a rather lengthy redaction, agreement. I assume this is a form of NDA. The second claim of relief, the first part of which is a repeat of the first claim of relief. Plaintiff and defendant have entered into a valid and binding contract supported by adequate consideration, the NDA. The NDA contains the following language. The parties agree that disclosure of pyramid information, included but not limited to company history, operations, affiliates, sensitive PII, to include but not limited to an individual's employment or ownership status in any organization unless it directly interferes with pyramid's operations, associated addresses and phone numbers, blank and blank any blank information, blank regarding and blank. There's a lot of blank there. Individuals' involvement in pyramid events or operations could cause irreparable harm to both pyramid and or its affiliates. So just Blair then. Upon information and belief, defendant is in breach of these agreements by sharing screenshots of company communications with defendant blank, intending that he use the screenshots as part of a campaign to damage Blair's reputation, as stated above in paragraph 63. Paragraph 63, Mr. Blank is in violation of the blank agreement by turning over private messages between himself and Blair to another YouTuber to exploit in a YouTube video made to slander plaintiff, titled Illuminaughtii and Sad Milk. The video referenced is from The Click's YouTube channel. Defendant blank has further established his intent to post additional content which will harm plaintiff Blair in a devastating manner, because that's what will do the damage. Right. As a result of defendant's breach, plaintiffs have incurred damages included but not limited to loss of revenue, future loss of revenue, pain and suffering, and attorney fees. It's funny to me how all this legal rubbish is being presented in this way when it can be shortened down. The whole document to Blair made a conscientious decision to be a dickhead and is now suffering the consequences of making that choice. Consequences are vitally important to understand. Positive, negative, neutral, they are quite common, of course they are. In this though, there is a correlation between crappy behaviour and then being found out. Now I said crappy behaviour because I can't say F around the full away because that meme has been done to death. Essentially, she done a bit too much of the crappy stuff and found out to the tune of hundreds of thousands of daily views lost and the loss of a huge subscriber base. Respect. Success, acclaim. Oh no, you'll have to show for it with your play buttons. What a shame. You can be so proud of that, by the way. Yes, you were an anti-MLM YouTuber on, well, YouTube for years. Maybe you should move to Rumble. Maybe you'll succeed there. Third claim of relief. Defamation per se as to defendant blank. On or about the 16th of September 2023, so Oz Media, as we can see in this part, published a video titled Let's Talk, an update on Illuminaughtii drama. In the video, Oz Media alleges that Blair is trying to prevent publication of the video remarks, which wouldn't be surprising considering Blair's alleged white-collar crime, so a repeat of an earlier argument, right? Oz Media clarified that the white-collar crime he was falsely accusing was embezzlement. Again, a repeat. This statement was published with at least negligent disregard for its truth because the defendant couldn't remember if this exact word was ever used. He nevertheless used the word embezzlement to describe Blair's actions. The statement is untrue regardless. Embezzlement is a crime, namely the crime of theft, citing law in the process. Oz Media negligently made a false allegation that Blair had committed a crime, which is defamation per se. There is something selectively peculiar about all of this. Blair could not earlier remember the agreement she had with somebody about paying mortgages, so others had to tell her about it and then had to arrange some repayment plan. But her memory is completely fine in this instance when she's accused of something. Considering the time frame this all happened in, I am somewhat impressed at the balls of it. Fourth claim of relief. In a video referenced in paragraph 46 of this complaint, which again, by the way, is Oz Media, a few quotes are now cited. Blair had bad credit, so all the purchases, loans and everything was being placed in my name. This would lead me to ask Blair, my partner, for financial help. Financial help for things such as my home which he was living in. These amount of assistance would be added to a ledger of debt. I even offered to work at her crypto farm for free to pay back the debt. Crypto farming? Oh. Yes, I'm rolling my eyes, get over yourselves. These statements were defamatory because they were misrepresentations of the facts, which caused Blair and Pyramid to be hated, ridiculed, shunned and harmed, plaintiff's business and trade, and caused reputational damages. These statements had the tendency to imply that Blair engaged in financial coercion, causing some form of indentured servitude, which it did. The comments on the webpage hosting the video are rife with viewers' statements of hatred and threats made towards Blair and Pyramid. So, they're comments on a video. They mean sod all. These statements were also false, and the defendant knew them to be false. Sure. For example, Ozmedia was an owner of a crypto farm he referenced in the video, plus Blair was paying almost $300,000 of defendant Ozmedia's expenses because he lacked the funds after he leased a brand new something worth about something. Was that a car or a house? Was it a rocket ship? The fifth claim of relief has no alterations to it, so we're not going to bother with that one. Although since this is based on Wonderstruck Guy, I'm not surprised it's not been changed at all. I do think we've covered this before. The sixth claim of relief. Blair and Pyramid hereby incorporate the previous paragraphs by reference as though each were fully set forth therein. On or about the 29th of June 2021, the defendant signed an agreement in which he agreed that he would maintain physical and liability coverage on a vehicle. The car would reside in Colorado during the duration of the rental period. Upon information and belief, the defendant did not maintain physical and liability insurance coverage for the car. Upon information and belief, the defendant took the car outside of the state, I believe, to a place in Texas even before the first rental payment was due in 2021. The defendant thus breached the agreement, and as the owner of the car, Blair was legally permitted to repossess it. In the My Response video, defendant claimed that Blair had no legal basis to repossess the car and did it merely as a massive FU. Upon information and belief, the censored word is feck. These statements were also false, and the defendant knew them to be false. These statements were defamatory because they were misrepresentations of the facts which caused Blair and Pyramid to be, oh geez, really that again? These statements had the tendency to imply that Blair didn't uphold her legal obligations and took special pleasure at causing others pain, something which, much like creepshow art, has been proven demonstrably true over the years. At this point, with so many people calling her out for crappy behaviour, yes, there'll be some bad faith actors, of course there will be in all batches, but far too much of it has been corroborated now. This is nonsense. The comments on the webpage hosting the video are rife with viewers' statements of hatred. Again, emotional damage meme somewhere. The defendant's statement caused special damages as evidenced by the fact that the plaintiff's revenue from videos dropped by more than 60%. So, for example, from $27,636,50 in the period from May to June to $10,000 during the same period a year later. Bitch, you're still making like 20 times what I make. What you complaining about? Like, fire some of your researchers and you can live more reasonably. Or get used to saying, would you like fries with that? Or maybe being an Uber, a Deliveroo, whichever's easiest for you. Blair suffered non-economic and special damages, as explained in paragraph 106, that is the cost part, as a result of defendant's publication in an amount to be proved at trial. All of this is quite tragic really for Blair, because all these amendments to this fully set forth therein document are laughable. A skewing of what is known as verifiable fact to drag out something for the sake of dragging it out. I assume because she believes she will win, which she's wrong to believe, and that all legal costs that have been incurred will be paid by the other side, not realizing here that when she loses, it's game over. She's dragging out something she cannot win. I believe this anyway. If the legal system is supposed to be justice, and justice is meant to be blind, like Lady Justice, then this should not be a win for Blair at all. The information is there. While the internet may well dislike Blair, the internet weaponizes certain more obsessive compulsive behavioral traits. When they do this, they collect, they archive everything. Hell, I've got a bunch of tweets of yours archived that you deleted. It's just one of those things we do to ensure that all information is there. And you seem to think yourself above this, which is quite frankly tragic, and you are still painting yourself as if your side of history makes you a martyr. I'm not entirely sure what you're a martyr for, but you're a martyr for something in your mind. There are pills for that. I highly recommend you get a psychological evaluation. Seventh claim for relief. Blair and Pyramid hereby incorporate blah 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 blah. On or about the 2nd of May 2023, defendant published a public tweet. This is Felix the Kit Kat. Included is an image from Felix's Twitter. My former employee Iilluminaughtii is retaliating against me for things I've said and done after my employment ended. She had falsely claimed to have served me papers and is trying to force a default judgment. If memory serves, this was sent to an address they had not lived at for years. This statement implies that Blair committed the tort of abuse of process, alleging an ulterior motive for the use of a judicial proceeding to retaliate for defendant, Kit Kat, Post-employment actions. The willful use of legal proceedings in an improper manner, trying to force a default judgment without properly serving the defendant. Damages. An impending default judgment against Felix the Kit Kat. These statements are false, and Felix the Kit Kat made the statement with negligent disregard for its falsity. Process server blank signed a declaration that she served defendant Felix the Kit Kat on the 26th of September 2023 at his place of abode, handing the requirement legal documents to an individual matching the physical description of Felix the Kit Kat. Felix the Kit Kat's statement caused special damages, as evidenced by the fact that the plaintiff's revenue dropped more than 95% after the tweet, from $74,000 for the month of November to December down to $2.7k. Well, you know, to make your bread at the right time of year. Can I have some of that money? Like, even the lower end? That'd be great. Bitch, you had everything. You threw it away. Blair suffered non-economic and special damages, referenced earlier. 8th claim for relief from the Clicks video. Blair and Pyramid hereby blah blah blah. On the 2nd of May, the Click posted a video to his public YouTube account, Iilluminaughtii and Sad Milk. Iilluminaughtii and Sad Milk video displayed a redacted screenshot of a Discord conversation. Upon information and belief, the relevant redacted portions obscure the username Felix the Kit Kat, the username of defendant, blah 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 blah. Now, what's funny about that image is those Discord messages, Blair tried to play defense with some of that, trying to make some of it disappear to make the conversation seem one way. Because unlike Twitter DMs, you can delete your DMs on Discord, but you have to go through it manually to do it. Yours only, you can't delete the other person's. As far as I'm aware, you can't archive Discord messages, so it's now impossible to replicate an accurate presentation or representation of what the DMs really were, especially when you know Blair's been deleting some of her own. Another image is included. Iilluminaughtii, I need you to work with somebody to help me find clicks saying the R slur in Sad Milk's raw audio. She offered to pay Felix $200 to find this. Now, we did cover that in my Iilluminaughtii video because Felix needed the cash, and I'll be honest, if you're being offered $200 to just watch videos and find one word, it's not overly difficult. Although you don't necessarily have to watch the content to find the word. You can have that with program, but apparently no one knows how to use that. Upon information and belief, Click is blank. Blair asked blank to find Click, saying the R slur in Sad Milk's raw audio. The defendant, Felix, then asserts that Blair, though she publicly disapproves of the R slur, uses it in private. I know many people who will happily use certain words in private that they won't use in public. How is this a surprise? We are not squeaky clean, honestly. The amount of times I've used the word moron in private, I know, highly offensive. Or maybe even reference somebody that I find moderately unattractive as congealed treacle. Honestly, we are not very nice people behind closed doors, which I am right now behind a microphone because I'm a dickhead. This statement carries a defamatory meaning because it implies that Blair is both a hypocrite and a bigot. She is. Again, demonstrably proven so. That DM shows it. That she was willing to look for it to prove her point. And others, lots of people in fact, have corroborated that she has in fact said it. Although to be honest, the word that begins with R has lost all meaning and is having a bit of a renaissance on social media, so give it time and it'll be more acceptable to say it. The defendant published this statement with negligent disregard for its truthfulness. The defendant's statements caused special damages. The statements caused an income drop of about 50% from $37,981 to $19,000 within the space of a year for same period earnings. I don't think it was that video that did it, but I like that you've equated the two like you did earlier with other videos dropping. That's quaint. I think that is you finding out the consequences for your own crappy behaviour, but you're so willing to die on this hill. It's quite frankly astonishing. Blair suffered non-economic and special damages. We're not done though. 9th claim of relief or for relief. Violation of the Computer Fraud and Abuse Act as to defendant blank. Blair and blah 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 blah. On the 10th of January 2023, the defendant accessed Blair's computer and read her personal conversations on Discord. The computer was stored in a room set aside for storing her personal belongings. The computer was password protected. How the defendant obtained the password is unknown, but Blair did not share it with him. Well, it turns out password 1234 is not as original or creative as everyone thinks it is. Of course, my passwords are quite easy. Mine are simply QWERTY. I bet someone's testing that now, aren't they? Blair did not share the password with this defendant or otherwise grant him permission to access her computer, much less her private conversations. The defendant knew he did not have authorization to access but accessed anyway. When the defendant accessed the private conversations stored on the computer, he learned that Blair was romantically involved. Are we going through this again? The defendant's romantic relationship had ended in December 2021. Learning of this information on the protected computer caused blank to plot a way to exact revenge, including publishing the defamatory Let's Talk video, which caused more than $45,000 in economic damages, as explained in paragraph 88. Oh, you really are dragging this shit out, aren't you? Thankfully, we're near the end. Prayer for relief. Wherefore? Plaintiff prays that this court enter judgment in favour of plaintiffs on their claims pled herein, including an award of pre- and post-judgment interest, attorney fees and costs, and any other relief that it deems reasonable and necessary from the 6th of February 2024. I know I'm a little bit late to the party on this one, but to be honest, I hadn't actually kept up to date with this as much as I should have. In fact, I was a full video behind on MadCatster's channel, and I received this a couple days ago, which is lovely, by the way. Thank you again for sending this my way. I really should make it more of a point to keep up to date with this, because this is fascinating to me. All these alterations, all this desperation to try and make it seem like one video cost you 45 grand, another cost you 35 grand, another cost you 20 grand, another cost you 60 grand. Like, no, that's not what happened at all. This is historical revisionism from somebody who is oddly enough acting like the very R slur that they claim to not use. And I find this all quite annoying, really. I feel sorry for those you are trying to drag, but I'm not surprised you haven't gone after others in other countries, because not only can you barely afford this, you couldn't afford to drag their asses to your country. I know I wouldn't have impacted any of your earnings in the slightest, because I'm a nobody. But let's face it here, you're an idiot. And you know you are, Blair, which is why you are so desperately pushing with this. These amendments are amusing, and I'm going to link the lawsuit dismissal video from MadCatster from 2 weeks ago, so you can understand why this is desperate. And it really is desperate.